Welcome back to another challenge video. As you can see by the title of this video, I am going to be reading all three of the founding documents: the Declaration of Independence, the Constitution, and the Bill of Rights, all in one sitting, back to back to back, to celebrate the 250th anniversary of the United States of America. And a few things before we get started. You will notice that this is being filmed on the 2nd of July. That's because I don't know what my 4th of July is going to look like, personally. So, I'm doing this ahead of time, now rather than later. And second, last thing, please subscribe because we are on the road to 1,000. It would mean so much more than you know. And God bless America. Happy 250th. The Declaration of Independence. Here we go. Oh, and one more thing. I do have a minor case of dyslexia, so I might mess up a few things here and there, but it shouldn't be too bad. Here we go. The Declaration of Independence, 1776. In Congress, July 4, 1776. The unanimous declaration of the 13 United States of America. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and rights that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence indeed will dictate that governments long established shall not be changed for light and transient causes, and accordingly all experience hath shewn that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and aspersions pursuing inversibility the same object evinces a design to reduce them under absolute despotism. 1 second. Okay. It is their right, it is their duty to throw off such government and to provide new guards for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrains them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. He has refused his assent to laws, the most wholesome and necessary for the public good. He has forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained, and when so suspended he has utterly neglected to attend them. He has refused to pass other laws for the accommodation of large districts of people, unless these people would relinquish the right of representation in the legislature, a right in the insensible, maybe, I don't know, to them and formidable to tyrants only. He has called together legislative bodies at places unusual, uncomfortable, and at distance. I'll get to all this in a second. And at distance from the viscosity of their public records, for the sole purpose of fatiguing them into compliance with his measures. He has dissolved representative houses repeatedly, for opposing with manly firmness his invasions on the rights of the people. He has refused for a long time after such dissolutions to cause others to be elected, whereby the legislative powers, incapable of annihilation, have returned to the people at large for their exercise, the state remaining in the meantime exposed to all of the dangers of invasion from without and convulsions within. He has endeavored to prevent the population of these states for that purpose, obstructing the laws of naturalization of foreigners, refusing to pass others to encourage their migrations hither, and raising the conditions of new appropriations of lands. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone for the tenure of their offices and the amount of and payment of their salaries. He has erected a multitude of new officers and sent hither swarms of officers to harass our people and eat out their substance, whatever that means. He has kept among us in times of peace standing armies without the consent of our legislators. He has affected to render the military independent of and superior to the civil power. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation for quartering large bodies of armed troops among us. There's an impostor among us, for protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states, for cutting off our trade with all parts of the world, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for transporting us beyond seas to be tried for pretended offenses, for abolishing the free system of English laws, in a neighboring province establishing therein an arbitrary government and enlarging its boundaries, so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments, for suspending our own legislators and decoloring themselves, investing with power to legislate for us in all cases whatsoever. He has evicted government here by declaring us out of his protection and waging war against us. He has plundered our seas, ravaged our coast, burnt our towns, and destroyed the lives of our people. He is at this time transporting large armies of foreign mercenaries to complete the works of death, desolation, and tyranny already begun, with circumstances of cruelty and perfidy scarcely scarcely paralleled in the most barbarous ages, and totally unworthy the head of a civilized nation. He has constrained our fellow citizens taken captive on the high seas to bear arms against their country, to become the executions of their friends and brethren, or to fall themselves by their hands. He has excited domestic insurrections amongst us, and has endeavored to bring on the inhabitants of our frontiers, the merciless Indian savages whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. In every stage of these oppressions we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant, is unfit to be the ruler of a free people. Nor have we been wanting in attentions to our British brethren. We have warned them from time to time of attempts by their legislator to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our immigration and settlement here. We have appealed to their native justice and magnanimity, whatever that means, and we have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They too have been deaf to the voice of justice and consanguinity. We must therefore acquiesce in the necessity which denounces our separation, and hold them as we hold the rest of mankind, enemies, and war and peace friends. We therefore, the representatives of the United States of America and General Congress, assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do in the name and by authority of the good people of these colonies, solemnly publish and declare that these united colonies are in a right ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is ought to be totally dissolved, and that as free and independent states they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all others acts and things which independent states may of right do, and for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. Here's all the signatures. I'll read this, but first I gotta... Whoa. But first I gotta get back up to this. Here we go. The delegates of the United Colonies of New Hampshire, Massachusetts Bay, Rhode Island, and Providence Plantation, Connecticut, New York, New Jersey, Pennsylvania, Newcastle, Kent, and Sussex and Delaware, Maryland, Virginia, North Carolina, and South Carolina, and Congress assembled at Philadelphia, resolved on the 10th of May, 1776, to recommend the respective assemblies and conventions of the United Colonies, where no government sufficient to the exigencies of their affairs have been established, right? Hold on, I'm lost. Okay, no, I'm not. To adopt such a government as should, in the opinion of the representatives of the people, best conduce to the happiness and safety of their constituents, in particular, and of America in general. A preamble to this resolution, agreed to on the 15th of May, stated the intention to suppress the exercise of every kind of authority under the British Crown. On the 7th of June, certain resolutions respecting independency were moved and seconded. On the 10th of June, it was resolved that a committee should be appointed to prepare a declaration to the following effect: the United Colonies are, and of right ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all our political connection between them and the state of Great Britain is and ought to be totally dissolved. On the preceding day, it was determined that the committee for preparing the declaration should consist of 5, and they were chosen accordingly in the following order: Mr. Jefferson, Mr. J. Adams, Mr. Franklin, Mr. Sherman, Mr. R. R. Livingston. On the 11th of June, a resolution was passed to appoint a committee to prepare and digest the form of a confederation to be entered into between the colonies, and another committee to prepare a plan of treaties to be proposed to foreign powers. On the 12th of June, it was resolved that a committee of Congress should be appointed by the name of a Board of War and Ordnance to consist of 5 members. On the 25th of June, a declaration of the deputies of Pennsylvania met in provincial conference, expressing their willingness to concur in a vote declaring the United Colonies free and independent states, which laid before Congress and read. On the 28th of June, the committee appointed to prepare a declaration of independence brought in a draught, which was read in order to lie on the table. On the 1st of July, a resolution of the Convention of Maryland passed the 28th of June, authorizing the deputies of that colony to concur in declaring the United Colonies free and independent states, was laid before Congress and read. On the same day, Congress resolved itself into a committee of the whole to take into consideration the resolution respecting independency. On the 2nd of July, a resolution declaring the colonies free and independent states was adopted. A declaration to that effect was on the same day and the following days taken into further consideration. Finally, on the 4th of July, the Declaration of Independence was agreed to, engrossed on papers signed by John Hancock as president, and directed to be sent to several assemblies, conventions, and committees or councils of safety in the several commanding officers of the Continental troops, and to be proclaimed in each of the United States, and at the hand of the army. It was also ordered to be entered upon the journals of Congress. It was, and on the 2nd of August, a copy engrossed on parchment was signed by all but one of the 56 signers, whose names appended to it. That one was Matthew Thornton of New Hampshire, who on taking a seat in November asked and obtained the privilege of signing it. Several who signed it on the 2nd of August were absent when it was adopted on the 4th of July, but approving of it, they thus signified their approbation. Note: the proof of the document, and as published above, was read by Mr. Ferdinand Jefferson, the keeper of the rules at the Department of State at Washington, who compared it with the facsimile of the original in his custody, custody. He says, in the fast mile, as in the original, the whole instrument runs on without a break. The fat dashes are mostly inserted. I have in this copy followed the arrangements of paragraphs adopted from in the publication of the declaration in the newspaper of John Dunlap, and has printed by him for the Congress, which printed copy is inserted in the original journal of the old Congress. The same paragraphs are also made by the author in the original draught, preserved in the Department of State. Now we go down here. Fortunes in our sacred honor, yep. John Hancock, New Hampshire. Josiah Bartlett, W.M. Whipple, Matthew Thornton, Massachusetts Bay. Samuel Adams, John Adams. I'm gonna guess Robert Treat Pine. Elbridge Gary, Stephen Hopkins, Rhode Island, William Ellery. Whoa. Connecticut, Roger Sherman, Samuel Huntington, M.W. Williams, Oliver Wolcott. Virginia, George Wythe, Thomas Nelson Jr., Richard Henry Lee, Francis Lightfoot, Thomas Jefferson, Francis Lightfoot Lee, probably Benjamin Harrison, Carter Braxton. Hold on. New York, W.M. Floyd, Phil Livingston, Franz Lewis, Lewis Morris. New Jersey, Richard Stockton, Gino Witherspoon, Franz Hopkinson, John Hart, Abra Clark. Pennsylvania, Robert Morris, Benjamin Rush, Benjamin Franklin, John Morton, Geo Clymer, Jack Smith, Geo Taylor, James Wilson, Geo Ross, Delaware. Caesar Rodney, Geo Ray, Theo McKean. Maryland, Samuel Chase, W.M. Packer, Fostone, Charles Carroll of Carlington. North Carolina, W.M. Hilper, Joseph Hewis, John Penn. I wonder if he's related to Sean Penn. South Carolina, Foss Hayward, Jr. Edward Rutledge, Thomas Lynch, Jr. Arthur Middleton, Georgia Button Jeweminet, Lehman Hall, Geo Walton. Note, Mr. Ferdinand Jefferson, keeper of the rolls in the Department of State of Washington, says, the names of the signers are spelled above as in the fast mile of the original, but the punctuation of them is not always the same. Neither do the names of the states appear in the fast mile of the original. The names of the signers of each state are grouped together in the fast mile of the original, except the name Matthew Thornton, which follows that of Oliver Wolcott. Well, that's the Constitution. No, that's the Declaration of Independence for you. Now we got the big one, the behemoth. I am going to be reading all 27 amendments. Let's waste no time. The Constitution of the United States. We the people of the United States. We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution of the United States of America. I gotta check so I don't get this wrong. Okay, Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be appointed among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumerations shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to just 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall just their Speaker and other officers, and shall have the sole power of impeachment. Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence for the first election, they shall have divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year, and if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. No person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers and also a President pro tempore in the absence of the Vice President, or when he shall exercise the office of the President of the United States of America. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable to subject to indictment, trial, judgment, and punishment according to law. I don't know what this is. I'm just going to read it. Each house shall keep a journal of its proceedings, and from time to time publish the same, excepting such parts as may, in their judgment, require secrecy, and the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, shall be entered on the journal. Neither house during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. I'm sweating. Hold on. Now I lost where I was. Section 4. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislator thereof, but the Congress may at any time by law make or alter such regulations, except as the places of choosing by senators. The Congress The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday of December, unless they shall by law appoint a different day. Section 5. Each house shall be the judge of the elections, return, and qualifications of its own members, and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day. It may be authorized to compel the attendance of absent members, in such manner and under such penalties as each house may provide. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. In the House of Session of Congress, or any place that which two houses shall be. Okay, neither house during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. I don't think I got that. Section 6. The senators and representatives shall receive a compensation for their services, to be ascertained by law, and paid out of the Treasury of the United States. They shall in all cases except treason, felony, and breach of the peace be privileged from arrest during their attendance at the session of their respective houses, and going to and returning from the same, and for any speech or debate in either house. They shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office. Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose to concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it with his objections to that house in which shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If after such reconsideration 2/3 of that house shall agree to pass the bill, it shall be sent together with the objections to the other house, by which it shall likewise be reconsidered, and if approved by 2/3 of that house, it shall become a law. But in all such cases the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and the House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect shall be approved by him, or being disapproved by him shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill. I'm sweating my balls off. Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states and with the Indian tribes, to establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States, to coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures, to provide the punishment of counterfeiting the securities in the current coin of the United States, to establish post offices and post roads, to promote the progress of science and useful arts by securing for limited times to authors and investors the exclusive right to their respective writings and discoveries, to continue tribunals inferior to the Supreme Court, to define and punish piracies and felonies committed to the high seas, and offenses against the law of nations, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to provide calling forth the militia to execute the laws of their union, suppress insurrections and repel invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as they may be employed in the service of the United States, reserving the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as made by section of particular states, in the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislator of the state in which the same shall be, through the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make laws which shall be necessary and proper for carrying into execution the foregoing powers, and of all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Hold on. Okay. Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation, not exceeding $10 for each person. The privilege of the right of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion for the public safety may require it. No bill of attainder or ex post facto law shall be passed. No capitation or other direct tax shall be laid, unless incorporation to the census or enumeration herein before directed to be taken. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, and pay duties in another. No money shall be drawn from the treasury but in consequence of appropriations made by the law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, except of any present emolument, office, or title of any kind whatever, from any king, prince, or foreign state. Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver, coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter any agreement or compact with another state or with a foreign power, or engage in war, unless actually invaded or in such imminent danger as will not admit of delay. Article 2. What am I doing? Article 2, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the terms of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislator thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their representative states and in their respective states, and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves, and they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the President, if such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president, and if no person have a majority, then from the 5 highest on the list, the said House shall make in like manner choose the President. But in choosing the President, the vote shall be taken by states, in representation from each state having 1 vote. A quorum for this purpose shall consist of a member of members from 2/3 of the states. A majority of all the states, shall be necessary to a choice. In every case, after the choice of the President, the person having the greatest number of votes of the electors shall be the Vice President. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the Vice President. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible for the office of President. Neither shall any person eligible to that office who shall not have attained to the age of 35 years and have been 14 years a resident within the United States. In case of the removal of the President from office, or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may by law provide for the case of removal, death, resignation, or inability both of the President and the Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until the disability be removed or a President shall be elected. The President shall, at stated times, receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States, or any of them, before he enter the execution of his office. He shall take the following oath or affirmation: I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states. When called into the actual service of the United States, he may require the opinion in writing of the principal of each of the executive departments upon subject relating to the duties of their respective offices. He shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power by and with the advice and consent of the Senate to make treaties provided 2/3 of the senators present concur, and he shall nominate and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. Section 3. He shall from time to time give the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them in case of disagreement between them, with respect of the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes of misdemeanors. Article 3. We're powering through this. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, as stated times, receive for their services a compensation which shall not be diminished during their continuance in office. Section 2. The judicial powers shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made, and which shall be made under their authority, to all cases affecting ambassadors and other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state, claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects, in all cases affecting ambassadors, other public ministers, and consuls, all those in which a state shall be party. The Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial be held in the state where the said crime shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may have directed. Section 3. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving the maiden comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood, or forfeiture except during the life of the person obtained. Article 4. I'm not good with Roman numerals. Article 4, Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. In the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and found in another state, shall demand of the execution authority of the state from which he fled, be delivered up to be removed from the state having jurisdiction of crime. No person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered upon claim of the party to whom such service or labor may be due. Section 3. New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states or parts of states without the consent of the legislators of the states concerned, as well as of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Section 4. The United States shall guarantee every state in this Union a republican form of government, and protect each of them against invasion, and on application of the legislator or of the executive when the legislator cannot be convened against domestic violence. Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or in the application of the legislators of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislators of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment in which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Article 6, I think. In all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding, the senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be acquired as a qualification to any office or public trust under the United States. Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same, done in convention by the unanimous consent of the states present the 17th day of September. Happy birthday, Patrick Mahomes, September 17, the 17th day of September in the year of our Lord, 1787, and of the independence of the United States of America, the 12th in witness whereof we have Harenudo subscribed our names. I'm gonna guess President Washington, and Deputy from Virginia, New Hampshire, John Langdon, Nicholas Gilman, Massachusetts, Nathaniel Gorman, Rufus King, Connecticut, W.M. Samuel Johnson, Roger Sherman, New York, Alexander Hamilton, I know that guy, New Jersey, Will Livingston, David Brearley, W.M. Patterson, Jonah Dayton, Pennsylvania, Benjamin Franklin, Thomas Mifflin, Rob Morris, Geo Clymer, Thos Fitzsimone, Jared Ingersoll, James Wilson, Gove Morris, Delaware, Geo Reed, Gunning Bedford, John Dickinson, Richard Bassett, Shaco Broom, Maryland, James McHenry, Dan of St. Coast, Jennifer, Dan Carroll, Dan Carroll, Virginia, John Blair, James Madison Jr., North Carolina, W.M. Blount, Richard Dobbs Spite, Hugh Williamson, South Carolina, J. Rutledge, Charles Coatsworth Penicky, Charles Penicky, Pierce Butler, Georgia, William Few, A.B.R. Baldwin, attest William Jackson, Secretary. In convention Monday, September 17th, 1787. Again, Patrick Mahomes was born on September 17th, so it's a good day all around. In convention Monday, September 17th, 1787, present the states of New Hampshire, Massachusetts, Connecticut, Mr. Hamilton from New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia resolved that the preceding Constitution be laid before the United States and Congress assembled, and that it is the opinion of this convention that it should afterwards be submitted to a convention of delegates chosen in each state by the people thereof under the recommendation of its legislator for their assent and ratification, and that each convention assenting to and ratifying the same should give notice thereof to the United States and Congress assembled. Resolved that it is the opinion of this convention that as soon as the conventions of 9 states shall have ratified this Constitution, the United States and Congress assembled should fix a day on which electors should be appointed by the states which shall have ratified the same, and the day on which and a day on which the electors should assemble to vote for the President, and the time and place for commencing proceedings under this Constitution. That after such publication of the electors should be appointed, and the senators and representatives elected, that the electors should meet on the day fixed for the election of the President, and should transmit their votes certified, signed, sealed, and directed as the Constitution requires, to the Secretary of the United States and Congress assembled, and that the senators and representatives should convene at the time and place assigned, that the senators should appoint a President of the Senate for the sole purpose of receiving, opening, and counting the votes for President, and that after he shall be chosen, the Congress together. Where am I? Hold on, I lost track. The Congress, together with the President, should without delay proceed to execute this Constitution by the unanimous order of convention. President General George Washington, and W. Jackson, Secretary. Language in brackets has been changed by amendment. We're on the home stretch, ladies and gentlemen. The amendments of the Constitution of the United States as ratified by the states. Did I say I'm reading all 27? Preamble to the Bill of Rights. Congress of the United States begun and held at the city of New York on Wednesday, the 4th of March. The conventions of a number of the states having, at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, and further of its powers, that further declaratory and restrictive clauses shall be added, and extending the ground of public confidence in the government will best ensure the beneficial ends of its institution. Resolved by the Senate and House of Representatives of the United States of America, and Congress assembled, 2/3 of both houses concurring, that the following articles be proposed to the legislators of the several states as amendments to the Constitution of the United States, all or any of which, when ratified by 3/4 of the said legislators, to be valid to all intents and purposes as part of the said Constitution, viz. Articles in addition to an amendment of the Constitution of the United States of America, proposed by Congress and ratified by the legislators of the several states, pursuant to the 5th article of the original Constitution. Note, the first 10 amendments to the Constitution were ratified December 15, 1791, and form what is known as the Bill of Rights. Okay. Amendment 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances, aka freedom of speech. Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 3. No soldier shall in the time of peace be quartered in any house without the consent of the owner, nor in the time of war, but in a manner to be prescribed by the law. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly prescribing the place to be searched and the persons or things to be seized. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 10. The power is not declared to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Amendment 11, passed by Congress March 4, 1794, ratified February 7, 1795. Note: a portion of Article 3, Section 2 of the Constitution was modified by the 11th Amendment. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens of or subjects of any foreign state. Amendment 12, passed by Congress December 9, 1803, ratified June 15, 1804. Note: a portion of Article 2, Section 1 of the Constitution, changed by the 12th Amendment. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the persons voted for as president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and of the number of votes for each, which they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the person having the highest numbers not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president, but in choosing the president, the vote shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them before the 4th day of March next following, then the Vice President shall act as President as in case of the death or other constitutional disability of the President. The person having the greatest number of votes as Vice President shall be the Vice President, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the two highest numbers on the list, the Senate shall choose the Vice President. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole member shall be necessary to a choice. But no person constitutionally ineligible to the office of President shall be eligible to that of Vice President of the United States, superseded by Section 3 of the 20th Amendment. Amendment 13. This is where it gets interesting right here. Amendment 13, passed by Congress January 31st, 1865, ratified December 6, 1865. Note a portion of Article 4, Section 2 of the Constitution was changed by the 13th Amendment. I'm sweating. Section 1, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. Section 2, Congress shall have power to enforce this article by appropriate legislation. Also, Section 2, maybe, representatives shall be appointed among... Wait. Okay, no, never mind. Amendment 14, I guess. Passed by Congress June 13, 1866, ratified July 9, 1867. Note Article 1, Section 2 of the Constitution was modified by Section 2 of the 14th Amendment. Amendment 14, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed, but when the right to vote in any election for the choice of electors for President and Vice President of the United States, Congress not Congress of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged except for participation in rebellion or other crime. The basis of representation therein shall be reduced in the proportion which the number of male citizens shall bear to the whole number of male citizens 21 years of age in such a state. Section 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who have previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Section 4. The validity of the public debt of the United States authorized by law, including debts incurred, payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid or insurrection or rebellion against the United States, or any claim of the loss of emancipation of any slave, with all such debts, obligations, and claims shall be held illegally and void. Section 5. The Congress shall have the power to enforce by appropriation the provisions of this article, changed by Section 1 of the 26th Amendment. This is where I'm lost on the Roman numerals. So Amendment XV, passed by Congress February 26, 1869, ratified February 3, 1870. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have the power to enforce this article by appropriate legislation. Amendment XVI, passed by Congress July 2, 1909. Oh, that's the date. Ratified February 3, 1913. Note Article 1, Section 9 of the Constitution was modified by the 16th Amendment. The Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. Amendment XVII, passed by Congress May 13, 1912, ratified April 8, 1913. Note Article 1, Section 3 of the Constitution was modified by the 17th Amendment. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislator may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. XVII, I said that. Amendment XVII, passed by Congress on December 18, 1917, ratified January 16, 1919, repealed by the 21 Amendment December 5, 1933. Section 1, after 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States, and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2, the Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. Section 3, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislators of the several states, as provided in the Constitution, within 7 years from the date of the submission hereof to the states by the Congress. Amendment XIX, passed by Congress June 4, 1919, ratified August 18, 1920. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. Amendment XX. Right? Yep. Amendment XX. Passed by Congress March 2, 1932, ratified January 23, 1933. Note Article 1, Section 4 of the Constitution was modified by Section 2 of this amendment. In addition, a portion of the 12th Amendment was superseded by Section 3. Amendment XX, Section 1. The terms of the President and Vice President shall end at noon on the 20th of January, and the terms of Senators and Representatives at noon on the 3rd of January of the years in which such terms would have ended if this article had not been ratified, in the terms of their successors shall then begin. Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January unless they shall by law appoint a different day. Section 3. If at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed for the beginning of his term, or if the President shall have failed to qualify, then the Vice President shall act as President until a President shall have qualified, and the Congress may by law provide for a case wherein neither a President-elect nor a Vice President shall have qualified, declaring who shall then act as President or the manner in which one who is to act shall be selected, and such person shall act accordingly until a President and Vice President has qualified. Section 4. The Congress may by law provide for the case on the death of any of the persons from whom the House of Representatives may choose a President whenever the right choice shall have devolved upon them, and for the case of the death of any of the persons for whom the Senate may shall for whom the Senate may choose a vice president whenever the right of choice shall have developed upon them. Section 5, Sections 1 and 2 shall take effect on the 15th day of October, following the ratification of this article. Section 6, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislators of 3/4 of the several states within 7 years from the date of its submission. Amendment XXI, passed by Congress February 20, 1933, ratified December 5, 1933. Section 1, the 18th article of this amendment of the Constitution of the United States is hereby replaced. Section 2, the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Section 3, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided in the Constitution within 7 years from the date of submission hereof to the state by Congress. Amendment XXII, passed by Congress March 21st, 1947, ratified February 27, 1951. Section 1, no person shall be elected to the office of the President more than twice, and no person who has held the office of President or has acted as President for more than 2 years of a term to which some other person was elected President shall be elected to the office of President more than once. But this article shall not apply to any person holding the office of President when this article was proposed by Congress, and shall not prevent any person who may be holding the office of President or acting as President during the term within this article becomes operative from holding the office of President or acting as President during the remainder of such term. Take a shot every time that says President. Section 2, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislators of 3/4 of the several states within 7 years from the date of its submission to the states by Congress. Amendment XXIII, passed by Congress June 16, 1960, ratified March 29, 1961. Section 1, the district constituting the seat of the government of the United States shall appoint in such manner as Congress may direct a member of electors of President and Vice President equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of President and Vice President to be electors appointed by a state, and they shall not meet in the district and perform such duties as provided by the 12th Article of Amendment. Section 2, the Congress shall have power to enforce this article by appropriate legislation. Amendment XXIV, passed by Congress August 27, 1962, ratified January 23, 1964. Section 1, the right of citizens of the United States to vote in any primary or other election for President or Vice President, for electors for President or Vice President, or for Senator or Representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or other state. Section 2, the Congress shall have power to enforce this by article appropriate legislation. Oh my god, this is the last one. Amendment XXV passed by Congress July 6, 1965, ratified February 10, 1967. Note Article 2, Section 1 of the Constitution was modified by the 25th Amendment. Section 1, in the case of the removal of the President from office or of the death of his resignation, the Vice President shall become President. Section 2, whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3, whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration is that he is unable to discharge the powers and duties of his office, and until he transmits them to a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Section 4, whenever the Vice President and a majority of either the principal officers of the executive departments or of such other bodies of Congress made by law provide, transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, and the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and majority of either the principal officers of the executive department or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon the Congress shall decide the issue, assembling within 48 hours for that purpose if not in session. If the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President, otherwise the President shall resume the powers and duties of his office. Amendment XXVI, passed by Congress March 23, 1971, ratified July 1, 1971. Note Amendment 14, Section 2 of the Constitution was modified by Section 1 of the 26th Amendment. Section 1, the right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or any state on account of age. Section 2, the Congress shall have power to enforce this article by appropriate legislation. Amendment XXVII, originally proposed September 25, 1789, ratified May 7, 1992. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. Whew. Well, that's the Constitution for you. The Bill of Rights. The Bill of Rights Handout 3, Bill of Rights ratified by the states on December 15, 1971. Preamble, Congress of the United States begun and held at the city of New York on Wednesday the 4th of March, 1789. The convention of a number of the states having at the same time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. Resolved by the Senate and House of Representatives of the United States of America, and Congress assembled 2/3 of both houses concurring, that the following articles be proposed to the legislators with the several states as amendments to the Constitution of the United States, all or any of which articles were ratified by 3/4 of the said legislators to be valid to all intents and purposes as part of the said Constitution, viz. Articles in addition to the amendment of the Constitution of the United States of America proposed by Congress and ratified by the legislators of the several states pursuant to the 5th article of the original Constitution. Amendment 1. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peacefully to assemble and to petition the government for a redress of grievances. Amendment 2. Well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 3. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person's things to be seized. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a persistent or indictment or of a grand jury, except in cases arising in the land or naval forces, or in the militia when in actual service in the time of war or public danger, nor shall any person be subject for the same offense but to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Amendment 7. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall be committed, which district shall have been previously asserted by law, and to be informed of the nature in case of the accusation to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 8. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in any court of the United States than according to the rules of the common law. I really need to pee. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Amendment 9. The enumeration in the Constitution of certain rights shall not be constructed to deny or disparage others retained by the people. Amendment 10. The powers not degraded to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Holy moly. I just read all of this. If that doesn't deserve a subscription, I don't know what does. And if you notice me sweating, that's because it's very hot outside. Like 90 degrees or something like that. It's almost 2 in the morning. I'm gonna go pee and get some rest. Happy 250th anniversary, America. I did that for you especially. God bless America, and to all a good night.